Hello, everyone. Thank you for joining us today at our Recenter lunchtime webinar. So we're excited to invite Matthew Trail here today. Just I'm not sure if that's feedback or is that just sound from the room. Okay, sorry about that. So we've got some colleagues joining us physically in a seminar room perhaps as well. So the Recenter is based at the University of Oxford in the Department of Education, and we do research all around children in care and children experienced of care and children with a social worker. So today's session, let me first introduce Matthew Trail. He's a research fellow at the Max Planck Institute for Research on Collected Goods in Bonn, Germany. He recently finished his PhD in law from the University of Bonn. We were just talking about that, finished in February. And prior to becoming a researcher, Matthew's worked for 15 years as an attorney for foster children in the US dependency system. He managed a team of attorneys in Texas and trained attorneys, social workers, volunteers, and members of the Texas judiciary in child welfare issues. Matthew's current research is about the intersection of legal decision-making and AI, very interesting area, within the child welfare system. And very importantly, he has more than 35 years experience as a tactical role-playing game master and has told us that he's always looking for new players. So definitely one thing to get in touch with Matthew after the session. On top of all of the thrilling insights that are going to be discussed about Matthew's book. So we are proud to present Matthew's thought-provoking new book that explores the complexities of children's rights, wishes, and participation in the foster care system. This work critically examines the widely used but often contested best interest standard and contrasts it with the concept of normalcy, which promotes a more typical everyday life for foster youth. Drawing on both legal analysis and child welfare research, the book reveals how fear and risk aversion can distort decision-making, ultimately to the detriment of the children involved. Matthew makes a compelling case for placing children's rights and voices at the centre of the foster care process, offering a fresh framework that begins with normalcy rather than mere protection. The book is called Foster Children, Rights and the Law, Best Interest, Normalcy and the Welfare System. And here to talk about it is Matthew. Thank you so much for joining us. And I'm going to hand over to you, Matthew. Thank you.
Thank y'all for having me. It's nice to see you again. I did want to point out that in this book, and the acknowledgements, the Recenter is thanked in there. So I really enjoyed my time hanging out there, and I appreciated all of the help you all provided. And I don't know if I'd have been able to get all this done without my time there. So thank you for having me, and it's nice to be able to keep in touch with you and such as well. As for the book itself, let me. You guys can see the PowerPoint screen, right? Okay. So I will say that I don't feel like I'm that great at making PowerPoints to begin with, and turning just a bunch of text into a PowerPoint slide has been an exercise in trying to find interesting visuals. I'm not sure I succeeded in that. So so this is my attempt from practicing law for 15 years and being frustrated all the time, I think is what led to this book. Like I'd have these discussions with caseworkers in the hallway or with other attorneys, and the term best interest got bounded back all the time. And it never seemed to mean the same thing. Like it meant one thing on Tuesday and another thing on Wednesday, and it meant something different to everyone who ever uttered them. And it always frustrated me. And I think that in some ways that's what led to me wanting to become a researcher is my frustration with this topic. And so I don't think a lot of what I'm going to say today is stuff you all are experts on this as well. And so what I was hoping to do with this book, I guess what I'm saying, you'll have heard a lot of this before. You all will know some things I'm going to tell you. What I hope to do with the book kind of put them together and hopefully show ways they all tie together in ways that maybe we haven't thought about before. And hopefully that leads to some better suggestions what to do with kids in the welfare system. So, but going forward, this is the book. We think about best interest of the child. We think about it as this kind of like universal standard. And as I was talking about, meeting folks in the hallway, you've got people who are interpreting it all the time. You've got attorneys and caseworkers, foster parents, court advocates, volunteers, teachers, and I'll get to the details on this, but it's often a subjective, inconsistent framework for making legal decisions. I'll go through this quickly because I know you all know sort of these things. We know that there's lots of kids in foster care. This is from the U.S. My book does talk about the U.K. and Europe and other parts of the world as well, but just for purposes of presentation, I'll probably mostly stick to the U.S. We know that there's more disproportionate amount of Black children, Hispanic children that get pulled in. We know that that kids have multiple placements. That a lot of they kind of roll in and roll out. When you're looking at Europe, these same trends kind of also keep well. Europeans are also bad with disproportionality. It might be slightly different population than what's in the U.S., but there's also disproportionality problems also with European and UK foster care systems. I don't have the figures for Europe, but I know in the U.S. like a large portion of children have disabilities in the system, or the system causes them to develop disabilities. Those are often the ones I represented as an attorney. We know they come in mostly for neglect, which again, you all know all this stuff. But, when people think about foster care, they're often thinking about children being beaten or hurt or some terrible crime being committed. And even though we've probably all seen that case, that's not what mostly comes in. Mostly kids come in for neglect, which looks a lot like poverty in lots of places, drug abuse, child behavior, but actual physical abuse and sexual abuse are much more rare for the children that come into care. So mostly kids are in different types of foster homes. This is just a little bit about where they're at. They tend to be, most of them foster homes are kinship homes. Again, this is U.S. data. Mostly the goal is to reunify them, mostly partially to adopt them, and a few of them, the goal is to age out, which is not really a goal, it's just like a failure of goals. In the book, I describe this in more detail, but essentially the court process is pretty similar and even though it's different states, the timing may vary, but essentially you have like an investigation, a removal, and then a court process. That court process might vary by 72 hours here and there, but it looks pretty similar across the United States. And in the book, I compared Texas and Pennsylvania just as examples of what of how a legal case might go through. But that's not super important. I was just trying to set the point of we know that foster kids have more or less not great outcomes, especially the ones that age out of care. They tend to be in homelessness. They tend to be arrested. A lot of them don't graduate. Poor health outcomes. People have tried to do some causality to these studies to see if it's actually foster care itself or the child welfare system itself or the poor conditions that kids came from. These are complicated, but there is some studies that suggest that there really is something going on with the child welfare system itself that helps with these poor outcomes. We've got a lot of adults that are interacting at multiple different systems. You've got hospitals and medical services, the schools, courthouses, juvenile justice, social services, and each of them kind of have their own definition of what best interest looks like, of what best interest could be, and they all have their own kind of like standards for their own kind of subjective biases for what best interest looks like, and all of these push down basically the voice of the child and the child's own vision for like what a normal life looks like, and so you've got. So not only have a kind of a vague standard, but you've got these multiple different agencies, multiple different services, all interpreting this vague standard from their own personal biases. So that's a system that I always raged against. So best interest itself. Let me get a little bit about the actual standard and why I think it sucks, because I do think it's, I'm not going to bury the lead. I don't like best interest. So, it's this central, it's almost universal. It's used in courts, it's used in agency decisions, placement services, and it literally pops up everywhere all across child welfare. Like it's like I said, all these different agencies that use it, but also the people at different administrative places within those agencies, and they're using the same standards for all of these different types of decisions. And then those definitions vary by state. So you could have a child in, I use the example in the book of there's a town called Texarkana, which, as you might imagine, is on the border of Texas and Arkansas. And depending on what side of the street you live on, you might have completely different best interest standards than the kid on the other side of the street. Not to mention the caseworkers and all the other stuff. So there's no single US definition. There's no single UK definition or European definition or New Zealand definition or anything. And different states kind of come up with their own factors. I think Oregon has emotional ties. Alabama says family reunification. And then those are usually like the factors that are inside the state statutes or what's inside case law. It gets further complicated because often the child welfare systems themselves have agency factors that are in like their agency regulations that might be slightly different than the state factors. And there is no federal factor. There's no federal definition in the United States for best interest. There's some Supreme Court decisions that have toyed with it, but never actually defined it. These are Texas. I'm a Texas attorney, also a Florida attorney, but these are the Texas decisions. And Texas does not have statutory standards. Their best interest standards all come from this one case. And I put them up there. This is not better or worse than any other standards that you from other states, but these I just show you because these are the ones that I did work with the most when I was in Texas. And you can see some of them make sense. Some of them are what you've seen in other places, but these are not the same in every different state. When Dr. Skavenes in Norway, she had looked at comparing best interest across several different nations, and her study was really interesting because she kind of identified 8 that were reasonably common, but said the only thing that was actually common in all of them were basically procedural requirements that were common to best interest. And so best interest means a lot of things to a lot of different people in a lot of different places. In the United States, they've also adopted, like, best interest has always been kind of a child welfare, child custody, family law sort of standard, but it's been also pulled into schools. There's something on Every Student Succeeds about foster kids in schools, where schools now make best interest decisions. U.S. Customs Enforcement, who are vying for the top villain in the world these days, also use it supposedly in their decisions. And even the pediatric the field has adopted best interest when overriding children objections for treatment or parental objections. And there's actually a whole set of literature in each of these separate fields about people debating this standard in those specific fields. But that standard all comes from the legal field, from child welfare. It's where they're pulling it from. And of course, everyone knows best interest, the CRC, best interest is the child primary consideration. This language is then been adapted in other global and regional treaties. It's been applied in a bunch of different courts, in the European Court of Human Rights and Court of Justice, and also every country's national courts. It is, yeah, and so the CRC was kind of like the floodgates in some way of spreading best interest across the world, as far as I can tell. Interestingly, I think it might be America's fault, best I can tell historically, for where this comes from. I actually thought it was going to be y'all's. I thought it was going to be a UK thing, but the first use of the term best interest seems to come from like an American case. And even though America is famously not a signer for the CRC, the United States was a big pusher of the CRC, helped draft it and helped like push it out. And so this is maybe one of the many things that might be America's fault. And so best interest today is this kind of like, and of course the definition has changed since the 1800s when it was first adopted into case law. but it's expanded over the centuries to become this kind of like all-encompassing thing that we now know it as. When there's not a lot of research that looks specifically at the question of how people apply it, but there's a few different studies asking judges, attorneys, foster parents, etc. And I don't have time to go into each one of these studies, but the general takeaway from all of them is that individuals in these different professions are making highly individualized decisions using the best interest standard. There's not any consensus of how people, even within the same profession, are conceptualizing best interest. One of the things that always frustrated me, and this is maybe a tiny bit of a sidebar, but it is that for legal representation, there is every other client in the world basically gets direct legal representation, meaning you come to me as an attorney and I represent your interest. I might tell you if you have a bad idea or something like that, but I represent your interest. And so, but children don't have that. And so in lots of parts of the state, lots of the world, children have attorneys who represent the child's best interest. Now, fortunately, when I worked in both Texas and Florida, I was always direct representation, which meant I represented the kid as if an adult came to me and told me what they wanted. But most of the country has these hybrid best interest models where the attorney kind of does what the kid asks them, represents them as they want, but then can default back to best interest representation. Basically, I'll do what I think is best for you. And there's a lot of literature where authors have legal scholars have said, attorneys are not trained to be making decisions in people's best interest. That's not what we do. We represent clients. I strongly agree with that. One of the things I will come to at the end of this is I really, really believe in direct representation. So the reasons I don't like best interest, these are not me. I mean, I wrote these in my book, but a lot of people have been writing these for years. It was interesting. One of the guys I quoted was this Robert Munkin from like 1973, and everything he put in his paper could be applied to 2025. It was very frustrating in some ways. But so we know best interest is indeterminate, it's inconsistent, it's got a ton of bias built into it. It also has conflicting rights, like the best interest of what's in the best interest of the parent versus the best interest of the child versus children, like siblings. All of these things come together to make just a terrible legal framework. Also, none of the best interest, I couldn't find any best interest standard anywhere in the world that had the weights. And so like maybe in the UK, there's 13 best interest factors, and in Germany, there's 15, but none of them weigh it. It's just like, these are the factors you can consider. And it doesn't tell you, oh, if you're a judge or decision maker, you should weigh this one more than that one. And so everyone brings their subjective experience, subjective, I would say, nonsense to how they weigh these individual factors. And so it lets you make whatever decision you want to. I'm showing you these three books. So these are like Council of Europe and like a UN and a European Asylum Office book. This one on the left was like 200 pages. This one on the right was like 160. And this one was like 80. And all three of these books used all those pages to describe what the words best interest means. And if you need 400 pages to describe what 5 words mean, that doesn't mean anything. Like if you need, like this book on the left had like 22 authors describing how to interpret best interest. There are entire law school courses that don't have this much literature attached. Like for constitutional law, you wouldn't read this many books. And that covers a lot more complex things than just these 5 words. So that's my rant against best interest. Normalcy, this is a new thing. This is about new 15 years old, where it comes from. The idea that like children should be able to have regular activities, they should be able to make decisions, explore their own interest. And one of the core things about this is it allows kids to like take their own risk, risk taking. One of the things it allows them to do is obtaining a driver's license, get a job, a prom, have a date, have a cell phone, participate in sports, just these kind of standard things that we think of as like every kid should be able to do. This had to be written into the law in the States. And so there's still barriers to it, like instability placements. Kids are in multiple placements, kids are in group homes, RTCs. I often had clients that are in like residential treatment centers, and they never got normalcy because the residential treatment center just couldn't be bothered, which is why I always try to get my kids out of those placements. This law uh, the first inklings of normalcy appeared back in California, and it was expanded in 2013 with Florida. I know it's hard to believe that Florida did anything good, but like Florida actually kind of was the person that kind of put this law out there. Basically, the idea that kids deserve normalcy, and there was an entire lobbying effort where kids came to the legislature and told legislators they weren't allowed to play on high school sport teams or go to prom. And the legislators passed this "Let Kids Be Kids" law. And then that became kind of the basis for a section of the federal Preventing Sex Trafficking and Strengthening Families Act, which really doesn't have mostly it's not about normalcy, but that's an entire chapter about normalcy that then became federal. And normalcy also differs across the states, depending on what state they're in. They have different activities that kind of like what is allowed and what's not allowed. Like literally Hawaii, normalcy includes surfing, and like in Wisconsin, normalcy includes snowboarding. Like these were specific cutout examples within their things. So it does have some interesting geological differences or geographical differences to it as well. But these are mostly the same about letting kids have a normal life. We know this is important because you know we need emotional social skills. We need it's good for brains for healing trauma. And basically, it's a basic human right. I would argue to live a normal life and not be essentially locked down someplace. One of the interesting things, I copy this, put this completely in the book. There's a New York's Council on Foster Care, and this is made up purely of care experience and children and youth who are currently in care. And they wrote like what they felt normalcy should look like. And I include the entire thing in my book. I'm going to show it to you. It's a little bit much to read. I know you don't have to read all 11 because I can. But I think what is really telling in this Bill of Rights about what they think they deserve to live a normal life is the words best interest are not in this thing at all. Like, they do not say their own best interest. And this is written by currently children, youth in care and aged out of care people. So words best interest don't show up. Again, other factor barriers to normalcy. There's this giant fear to let kids have a normal life. There's some lack of transportation. A lot of kids want to drive, and not every foster kid's going to have a car. There's also discrimination for LGBTQ youth and those with disabilities or challenging behaviors. Like that's often a reason that homes will keep kids from normalcy. The normalcy laws often like have protections for parents who like basically tort law protection that keeps the foster parents held liable if a kid gets hurt while they're doing one of these things, but still the fear kind of guides on, so kids still are denied normalcy. There's not a ton of research been on this because it's really only kind of like taken off in the past decade. The Texas Youth Permanency Study has actually been following a cohort of kids for like 5 years now, and what they found, and there's still a few more years done with their study, but in their first 3 years, basically they found that like normalcy was more important than even stability for kids' own self-esteem, for their own sense of well-being. And so I thought that was an interesting finding. International context. So normalcy is a term you only really see in like the US, but there's similar stuff in the rest of the world. You all have kind of age-appropriate risks, and it's built into your care guidelines, and those are similar in Australia, New Zealand, EU as well. It doesn't quite have the same everything I could look at. I couldn't figure out something that's kind of like a one-for-one normalcy. There's some decent argument about the right to play that encompasses a decent portion of what normalcy looks like. Although normalcy is more than play; it's also getting a job and being more than just play, I guess. There's some critiques of normalcy saying this also could be subjective, like best interest as well. I think that's true. I think what normal to you, what normal to me, and what normal to a kid in New Mexico or Germany looks like could be different. But I still think it's a better standard than best interest for what I'm looking at. I'm trying to move quickly through these things. So risk, best interest, normalcy. How do these things kind of tie together? They're both aimed for like the idea of child stability. But my argument is that best interest is so safety oriented. It's risk averse. It's undefined, just let you default to safety. And normalcy its default is risk tolerance. So, you know, one of the things that we've seen is that we have this risk aversion that runs through child protection. It's not just child protection. I found some decent literature that says basically like risk aversion is on the rise for children everywhere for the past several decades. Essentially, normalcy is the idea that, you know, the kids can take these risks. Unfortunately, in the normalcy statutes and the normalcy rules, the words best interest are put into it, and so best interest can still override normalcy. The lawyer in me would argue that was meant to limit liability and not as like an override for normalcy activities, but the words are still there. The standard for protecting foster parents is called the reasonable prudent parent standard. But again, like I said, it basically lets parents, it has best interest built into it. And so even when you're trying to promote normalcy activities, which could be going to prom or driving or hunting or surfing, something like that, it still has this best interest built into it that can allow people to default to safety. And again, this is more than just child welfare. There's kind of this societal trend for risk aversion. There were some examples of places that basically criminalized like kids walking home from school or staying home. There were some examples of like in New England, I think it was Vermont, that it criminalized like 12-year-olds couldn't stay by themselves at home. Like that was enough to justify a CPS investigation if you let your like 12-year-olds stay by themselves. And so as the world has become more cautious about children and more fearful of what children are doing, more risk averse, that of course has bled over into child welfare as well. And like I said before, we know that like children need independence. They need to be able to take risk. We know that leads to poor outcomes. And I really like this quote from the Canadian Pediatric Society, that the goal really should be children as safe as necessary, not safe as possible. Because when we prioritize safety, we are sacrificing other parts on well-being, and I'll get to some well-being here in a second. Oh yeah, here's well-being. And so like this is one of the standard like well-being metrics, and you can see that like safe is on it. And I don't think anybody here doesn't want children safe, but there's more to life. There's more to a child's life, to everyone's life, than just safety. And best interest basically allows people to default to safety because it's ultimately risk averse. And I assume you guys all know Professor Monroe. She was nice to talk to me a couple of years ago, and I quote her review. I think this one was from 2011, but then the follow-up review in like 2019 had basically the same problems. And she's talking about risk aversion in the child welfare system back then. Like one of the primary things she identified was that the child welfare system was so risk averse, and there's this like defensiveness to it. Basically, whenever there's a mistake, child welfare employees basically live in fear of mistakes, and so best interest allows them just to default to safety. And like this, there was some study, I found some study about media and child welfare, and this is what people with the entire child welfare system lives in fear of, is being on the news when a child dies within their care for lack of investigation. And often when one of these things happens, you see an increase in like children removed and investigations as basically it's kind of an overreaction. Like, oh, we let a kid die in care. Now we have to like take in more kids. We have to be more risk averse. And so it kind of is like bad feedback loop between like media and there was one study that looked at media representation, and this is not super surprising, but like mostly when the media says the words child welfare, foster care, it's because something bad has happened. Like if it's in the paper or on the news, it's because something bad has happened in child welfare or foster care. And so that leads it to what caseworkers fear. I think this, as I keep saying, enables risk aversion and professional cover for limiting youth autonomy. Like you know, we can always revert back to safety and best interest as a malleable, whatever you want it to mean, legal standard allows you to pick whatever is the least risky for you, not necessarily for the best for you as the caseworker or as the volunteer or as the foster parent. Yeah, so decision making. I did want to talk a little bit also about like how we make decisions, because this is all coming into how we make best interest decisions. Best interest is still at the heart of all of these decisions, from removal to, and all of them are filtered through this best interest framework. One of the things we know about decision making in child welfare is that we never have really the full information, and even our guesses about what's going to happen are there's big gaps in what we know, we don't know, and we're asked to predict the future. And we also don't know, when we think about best interest, asked, what does the best interest look like? Are we talking about what's best for them if they want to go to college later, if they want to have a healthy relationship, if they want to become a carpenter? We're asked to predict the future all the time using this framework when we don't have the information, to make that sort of deterministic decision. So you all probably, I'm not sure if this looks exactly the same in the UK, but I suspect it's similar. Key decisions, screening of substantiation, removal, termination, reunification. You all probably know what those look like. We know that lots of screenings are not accurate. We know that screenings come in. If a professional, if a doctor or a cop or something calls in their screening, it's more likely to get investigated. We also, the study showed that agency workers and office culture influence people's screening and investigation decisions. Same thing with substantiation or removal decisions, like basically racial income, geographic disparities, all change how decisions are made on these two decisions. Also, again, worker risk tolerance and community supports shape removal choices. And there's a ton of literature on decision making that I discuss in the book about going through each of these types of decisions. So I think we know a lot about decision making, but it's not been like put together in like a good. No one's really come up with a unified theory of decision making and care. We know judges also have bias and have their own problems with the decision making and the research on that. We know that they when you ask them, they'll talk about the statutory factors that guide them, but then judges will end up making different decisions based on different types of cases. So, like for instance, in the European Court of Human Rights, whenever they're talking about reunification, like if a refugee case under best interest versus like a send back to the country of origin case, even though it's the same best interest factors, they'll emphasize different ones depending on what type of case it is, which is kind of interesting. Case factors, I mean, these are not things that are shocking to you. Kids' age, behavior, type of maltreatment. These are sort of factors that all of these research can point to what changes decision making or moves decision making. We know there's also a ton of biases within foster care, both overt, less overt, but also some racial bias that's built in. We know that one of the things that people do is they don't like, and I think Dr. Moreau talked about this as well. People don't like to admit when they're wrong, and so like they'll focus a bunch of attention on the first bad factor they saw, and then not be willing to like back off of that. And so that's something that also there's study happened with judges. Basically, judges get anchored to some of the first things that happens in cases. These are some of the models that have been tried to come up with for kind of decision making, team decision making, family group decision making. We try to put together some different types of groups of ways to help decision making, because you all are well aware there's tons of literature on decision making in child welfare. The one I like the best that tries to put this together is the decision making ecology that John Fluke and them use. I think this is probably as good as anyone's going to get, although I don't think it really takes into account judicial and legal decisions quite as well. And so I think I've actually talked to John about this. Like this needs to be expanded to include judges' decisions in some form or fashion. I don't quite know how to do that, but I've suggested it to him. I really think of decisions as being more. It's like I call it like a decision river, because it's not just, we think of like the big decisions in the case of like, we're going to remove the child, or we're going to place siblings together, or we're going to terminate the parents, but there's really all these like small decisions that come up every day, like is the child going to go to this school? Are they going to be able to take band? Are they going to be able to attend the court hearing? Is there can they go to their friend's house? And those small decisions all of our small decisions are our life. Like, our lives are made up of small decisions, and children's lives are made up of these small decisions as well. It's not just these like 5 big case decisions. All these other agencies that come into play, the services, they're all making small decisions as well. And part of my argument is these small decisions ultimately are as important as some of these big decisions when they're kind of added up together. All right, children's rights. I'm going to try to go through this quickly because we know children have rights. This is all the ones that's listed on the CRC. You all know this: the protection, provision, participation are the ones that are kind of like, the lumped into the groups of rights. One of the things that was interesting when I was writing this is I'd never thought about what a kid meant before. Like, what is a child? And there's fortunately philosophers have thought about this question. So there's like the definition of a child. Like, you look at this picture up here. Like, this little kid's probably a kid, but like, is this guy a kid? Is this young lady a kid? And so when you even look at the legal definition, like even in Europe and in the States, like you can get a job at one age, and you can smoke at a different age, and you can have sex at another age. You can consent to medical treatment at a different age, and all those are often like under 18. And so even our legal definition of a child really depends on the specific legal context. So we don't have a good legal definition for what a child is, which is kind of crazy. I honestly not thought about that till I wrote this book. But, so kids have children's rights. We international, of course, we have the CRC. The U.S. context, we have some rights. There's some federal rights, mostly about juvenile justice and things, but there's not any like giant children's rights, bill. There are some foster care bill of rights in various states. There's maybe like 25 states that have them. And in the 7 states that have enforceable rights, those are really good rights. But most of them have this kind of like aspirational rights. And so they might as well, not exist. One of the things that I liked about the children's rights for participation is I really like Professor Lundy's model. I think it's a good place for thinking about participation, because when we think about children's rights, this is the one that often gets highlighted the most for child welfare. Like if only the kids can participate in court, then everything else is fine. I don't think that's necessarily true, but I do think this is probably the best way to look at it is the Lundy model. Let's see, I can skip through because I want to get to some questions as well. We know that kids say in the research that they want more participation, they want more access, more influence on what's going on. Often we know in the research that kids don't even know the rights that they're supposed to have. When we go back and talk to foster youth, they often don't even know what rights they are supposed to have under the statute. This is one of the things that the United States has done to try to help with some of these problems. Is there's been some big lawsuits against states. This lady's name is Judge Jack. She's in Texas, and she's awesome. She has been hammering the state of Texas for years. She finally annoyed them so much they've got an appeal to kick her off. But she spent about a decade telling the state of Texas foster care system that they were bad, which makes me love her. Normalcy. So this is my last thing, and I'll get to it. So does everyone remember COVID, like that thing that happened a few years ago? We were all locked down, and everyone was lamenting their normal life. Yeah. So if you go back and look at 2020, there's all these articles where people are talking about, when can we get back to normal? When can we get back to normal? What will normal even look like again? And all of us collectively as adults kind of lost our minds for the 3 to 6 months that we were in lockdown and the entire COVID experience. And so I want you to think about that, how crazy we all got from this kind of temporary experience of being locked down, of having the lack of normal life, and then apply that to children in care who have never had a normal life, who are always denied these kind of routine experiences of seeing their friends or going out or joining a football team or something. So back to my thing, we know that best interest, it's bad. I'm willing to fight anybody who thinks that best interest is good. I think it really lends itself back into whatever adult decision anyone wants to make, and then supports risk aversion. I think there's some good scholarship, people suggesting other things. This book is from the 90s, and they've suggested the least detrimental alternative. Basically, what's the least bad thing we can do And this was actually really popular for a few years in the 90s, but then kind of fell off. But I think it's a decent starting point. And then Professor Daly's book as well. She suggests basically autonomy in the courtroom. She doesn't quite object best interest, but I still think she's got a really good start with it. What I'm suggesting, I've called it my normalcy charter because I couldn't come up with a better word. So I just, that's what I went with. But so what I think children need is they need to have clearly enforceable rights, not just aspirations. They need actual rights, and those rights need to be be able to take into court, and they need direct attorney representation through them. And those rights, I think, will have risk tolerance built in. Like it's easy under best interest, always like go back to risk aversion, to safety over all things. But if a kid has a right to something, then I think the risk tolerances would be structurally built into those rights. What rights should I think I list like 18 or 19 in the book. There's just a few of them. I think the entire thing that I showed you that those children, those youth wrote for what they thought normalcy should look like, I think that should be it. Like I think those are great. I think children have a right to least restrictive placement, to bodily and medical autonomy, to appeal, protection from discrimination. And a lot of these rights actually exist hodgepodge here or there. Like I bet if you looked at some court someplace in the UK, you probably could find some courts enforcing some of these rights or most of them. And you could probably find some other court in Spain that's doing some of it, and some court in New Zealand that's doing some of them. But like there's no universal standard for these rights. I know with the CRC, but as I said, the CRC's got best interest built into it. So I think all these rights need to be enforceable in court. And I think that's really important, is it doesn't do any good to have, that's why the CRC rights are not all that useful, because they don't really have like great enforceability to them. Like the attorney in me knows that like nothing really exists unless a judge can order you to do something. That's how you get, that's called a remedy. And if there's a violation of rights, you need a remedy. And the only people who remedy things are courts. And so there's I don't think there should be a best interest override in it. There's some discussion about like an imminent safety override. I would have youth help draft and revise what they think all of these rights should be. I don't think I'm qualified to come up with what everyone's rights should be. For instance, for like the safety override, I had a client who got bit by a dog. And he was refusing to get his rabies shot. And as representing him as a direct attorney, I have to come to the court and say, Judge, my client doesn't want to get his rabies shot. And of course, if the dog actually had rabies, he's going to die in like 70, a week. Like he's going to be dead if he doesn't get his shot. But the court wisely overruled me and my client and ordered him to get the shot because he's 14 and he's dumb, and so he had to get that medical treatment. And so I think there's a fear that if we let children have rights, then they'll go do all sorts of crazy stuff. But like people come to court every day with ridiculous requests, and courts kick them out. Like there's just because someone has rights doesn't mean that they get it, that automatically everything able to happens in their life. So I think we need to embrace risk tolerance. Our rights based these rights. I think, like I said before, remove the aversion to risk. And I actually think it also is going to help caseworkers also, because as we talked beforehand, there's this giant fear of blame and risk aversion that runs throughout the child welfare agencies. Like every child welfare agency has a giant turnover problem all the time. And I think if they were less scared, if they could occasionally take risk, I would hear from caseworkers myself who'd be like, God, I really want to do this thing that that your client wants, but I can't because I'll get in trouble with my supervisor. And if we trusted the people the frontline people a little better, I think we'd have better outcomes. I think normalcy should be built directly into this. Normalcy should be part of these enforceable rights. I think kids should be be child-centered. I feel like a lot of things, I'm not saying anything that people haven't said before. I'm just trying to put it all together in one framework. I think the CRC is great. I don't think it really gets us to there. I've suggested that we have if you're going to put up something, we need, just like there's a convention on disability rights, I think we need a specific international guidance for foster kids, because I think the CRC is about every kid, and a lot of things that are unique to foster kids, to children in care, get left out of it or get misinterpreted through it. And so I think we need another guiding document to tell us what this should look like. So I think that's yeah. So we know we've always said crisis. If you go back and look at Google the words foster care crisis or child welfare crisis, and then put in the date, there's always a new crisis. And so this this system is always on the verge of collapse, I think, I mean, I think we could try something different. And so that's the gist of my book.
Thank you so much, Matthew. Yeah, really thought-provoking, which I think we expected when we all kind of registered for today's session. So I've got a couple of questions that I've been formulating, but I would encourage anybody online, please put your questions into the chat or raise your hand electronically, and then I can come to you. And also in the room, I'm going to ask Chris if you could help me to know if somebody in the room with you would like to ask a question. Can you raise your hand on the device, and then we can draw comments from the room as well for anyone that's there in person in Oxford. So I had a question, and I think you started to touch on it a little bit, but my question is a little bit broad. So I was thinking, who gets to decide then what is normal? So you touched on geography plays a part, and I'm wondering if maybe it's kind of community norms as well. What's normal in the community we might consider a normal kind of activity that a foster child might be supported to access. But generally, like, who decides what's normal?
Yeah, I mean, I think you have to let it be some geographic. I think the examples of like Hawaii letting you surf and Wisconsin letting you snowboard are interesting, because I think each country would come up with their own list. I do think there's some universal things that I think, like the stuff like privacy and, you know, being able to communicate to somebody without someone like, you know, those both like privacy in your personal space and privacy in your communications, you know, the ability to participate in extracurricular activities, whatever those might look like in your community. Like, so I do think while it's geographic, there are some concrete things that you could lock in regardless of the geography. I would argue like letting teenagers date or something like that would be high on my list, but I don't, maybe some places wouldn't like that one either.
Yeah. Well, yeah, and geography and culture and religious and ethnic and racial beliefs, you know, all of that, yeah, might direct. And you put on your slide, you know, how do we avoid it just becoming the white middle class version of norm?
Yes.
As well. Yeah. Thank you. Okay, so I can see somebody's raised their hand, so I'm going to ask Asma to bring your question.
Hi, Helen. Thank you. Can you hear me properly?
Yes, it's clear.
Okay, thank you. Well, first of all, Matthew, it's a great book. It was very informative for you. And myself being an expert in practitioner in child development and education, so I'm very much interested in this thing. But there is one thing that really brought me to this event specifically. I want some enlightenment. We have personally experienced such a very unfortunate incident in our family. My sister has suffered from something like that, where so my question is like, why the naturally or genuinely caring parent is treated as a criminal, kind of a criminal by the care system. So she was quite educated and doing very well in her child care and everything. And the only thing that she just reported an abuse by the father, and she ended up actually losing her children. So what do you have to say or advise in this regard? You know, it's very sad reality, and I wonder, would this thing would ever come to an end?
Thank you, Asma. Matthew.
Ever come to, I don't know. That's the specifics of any particular one child welfare case are specific to that case. I would say one of the things, as I pointed out with my ongoing rant against best interest, is that all it takes is one caseworker, one supervisor filtering that standard through their own bias, through their own fears, through their own lens, and then the case is off. You know, then it started. And then once the case is started, there's momentum to it. And then I think the risk aversion builds up from that point. And so that's one of the reasons that I think is the problem, is that we've got this best interest that just allows people to do what they want to.
Yeah.
And ultimately, you can usually get a court to come in and stop it at some point, but that's hard to do unless you have an attorney representing. And even then, the court's got their own biases, and they're still following a best interest standard, which if they are still kind of leaning in on this kind of like idea of risk aversion, and I don't want to make the news. Like I can't emphasize enough how many people make decisions based on I don't want to be on the news.
And that's that fear and that risk aversion directing. Yeah.
Right. And so we know a child is safe. We can put them in a box, put some food under the door, and they won't die. Show them some sunlight, but they're not well. They're not healthy.
Yeah.
So all these things that actually make a life worth living is more than just safety. But safety is the one that gets you in the news.
So we've got a hand raised. Ellie has a hand raised, and she's also put an interesting comment into the chat, which I was going to read out, but instead I'll let Ellie come in with a comment. Great to see you, Ellie.
Great to see you too. I'm Matthew. Thank you for the great presentation. So I'm Ellie Ott. I'm Associate Director for Research and Data at the Nuffield Family Justice Observatory. I used to be at the Reese Center some years ago, so lovely to see some familiar faces. Very interesting presentation, a lot in there. I put in the chat just thinking about safer caring and some of the frameworks we have in the UK and how maybe it aligns. And my brain is thinking there was a lot in there about kind of the role of the courts, as well as maybe the role of foster care and regulations and training. So safer caring isn't a court framework, it's a framework we have for kind of training foster carers and thinking about risk. And trying to get people to accept risk more in this very kind of risk adverse system. So my question was really about thinking about implementing this idea of normalcy. So say you create that rights framework with the young people and it's place-based. How do you implement it? What is the role of the court versus regulation or foster care? Do you have any kind of thoughts around that, Matthew?
I can tell you in the places that I've seen it done well, if you've got buy-in from the courts, then it helps. If so, in parts of Texas where I worked, that there was training specifically for like judges and for some of the higher up child welfare staff. And once you got that buy-in, that it became a little easier to calm the nerves of the foster parent or the frontline child welfare worker that this is something that's not going to get you in trouble. And so some of it is just a matter of training once the framework is in place. And I think it works better for children who are in long-term foster placements. It's the kids who are bouncing around, who don't have stability, who don't, especially the kids in group homes or treatment centers, where they've got all these safety rules that prevent them from doing anything like a normal life. And so honestly, I don't know how you'd ever get them on board other than shut them down. But if the right people in the right managerial power positions buy in, it'll make the rest of the system flow a little better, is my experience in seeing in practice.
Thank you. So Leon, you have your electronic hand raised. Would you like to ask Matthew a question?
Yeah, thanks, Helen, and congratulations, Matthew, on the book and all the progress since we've seen you at Reese, and great to see. And thanks for your presentation too, which was challenging and thought-provoking, and it's a very interesting kind of perspective that you've taken on this question. I'd love to know. Unfortunately, Julie Selwyn isn't here today. I'd love to know her take on this. And I just wanted to push you a bit on the nature of the argument. I don't want to. You said you would fight anybody who disagreed with you.
I'm ready to fight. Go ahead.
I don't want to get into a fight. But I just wondered. I mean, some of the things you're describing as problems of the system. Risk aversion, over concern for safety above other elements of normal living, procedure and process over care and well-being, and the poor level of definition of best interest. I mean, I recognize all those points. I just wonder how many of them are really, how many of the the underlying problems here are the issue of best interest and rights, and how much they are actually problems of culture and stigma and beliefs and understanding and systems, and that best interests gives a lever and a way of framing progress without which we would suffer worse outcomes and systems. So I just wanted to give you a chance to give us a couple more to kind of hone your argument for us in a few lines about what is it with best interest that you're so, you know,
So-
is it really the cause of the problems?
No. I don't think so. I wouldn't go so far as to say it's the cause of the problem. And again, I'm an attorney, so I'm thinking about this as a legal framework in which we make these decisions every day. I would never go so far as to say best interest is responsible for all the poor outcomes in foster care. What I'm arguing is I think best interest allows everyone to make bad decisions in foster care, and allows them to defend bad decisions using this framework, because the framework doesn't mean anything. It's a post hoc excuse for whatever decision you want to make for whatever child at whatever stage in the case, at whatever placement. And so I do think rights. I really do be a big believer in children's rights. And I think if a child had a right that I could take to court, like, judge, this child has a right to participate in after school activities and a right to send text messages to their paramour, like, not, I would say age appropriate, et cetera. Like, we'll have a little safety, and they're like, I could take that to court, but as long as, and then the judge could, hopefully agree that, oh yeah, this right is being violated, just like if you have due process rights. But as long as that right doesn't exist, it's always just, oh, we don't think this is right, Your Honor, because this is, they might get hurt, or we think it's best for them to be in this treatment program because they have a drug problem when they were younger. And so it just becomes this subjective, unfair way of forcing everyone else's ideas onto children, and then defending bad decision making. I really do think I would say that best interest is not the cause for all the problems in foster care, but I do think best interest is one of the causal problems for risk aversion. I would make that argument. I think it supports risk aversion at its very core. Now, not maybe there's probably more. There's some confounders in there as well, but I do think that's happening.
Thank you. I know. Do you think that's true globally, or specifically in relation to the US or other kind of contexts?
I was quoting on a lot of UK data. Professor Monroe was talking about y'all system in 2011 for a first report, and so I think it's everywhere. I think it's best interest allows even in like the high European courts, because the Norwegians are always doing really interesting research for like what those big courts doing. And so there's a bunch of Norwegian studies where they looked at, like, here's what this court was looking at refugees, here's what they're looking at as returning children, here's what they're looking at for parental termination. And the best interest standards, even for the same judge in the same court, is all over the place. And I know there's an argument to be made that, like, best interest, like, that's the purpose of the standards, that we can apply it in any different way. But if you can apply it in any different way, it's not really a standard. It's not a legal framework to actually make consistent decision making. Yeah, I think it's everywhere.
Thank you.
Thank you. Thank you so much. So we finished right on time, so we will end the session there. But yeah, I think in the circulation about the session, you've got Matthew's details. So if you want to try and get in touch and contact Matthew at Max Planck, you can reach out and do that. But please keep an eye out for our next lunchtime webinar coming up. It probably be after the summer now. We've got a new series starting, which is going to be focusing on the element of stability and different kind of aspects of research and ideas around that. So thank you everyone for joining us this afternoon, and have a good rest of the day.